Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about child luring. Cases that should have gone to the Supreme Court of Canada, but didn't. Richard McSween was charged with child luring offenses after he was engaged in a text message-based relationship with a teenager. He wasn't attempting, apparently, to lure the teenager he was texting, but rather the teenager's friend, sending him messages suggesting that he obtain explicit photos from his friend, that he was interested in seeing his friend naked, and other conversations like that. Ultimately, those text messages were admitted into evidence and used against him to prove the counts at trial. Unlike video evidence or recordings of conversations, text messages, as we all know, don't necessarily convey tone. And Mr. McSween argued at his trial that he was attempting to make jokes in the conversations and not attempting to lure the child. He also claimed that the requests for photographs to be provided to him were just jokes. And the question that ultimately arose in his case was whether or not joking was sufficient to meet the definition of child luring, which the court determined that it was. Even if they accepted that he was joking, which they didn't, they found that he would still have been guilty of the offense. And this raises really important legal questions about whether the sufficient mens rea is there, the mental intent to commit the offense, if a person is only joking. The court has to grapple with these issues, and if a person lacks the intent to commit the offense because they're joking, even if the jokes are weird and inappropriate, then how can they be guilty of that offense? And how can they be guilty of committing the conduct, that the societal ill that these child luring provisions are aimed at? The Supreme Court of Canada had the opportunity here to grapple with two important issues that affect the justice system. One is the mental intent requirement in child luring cases and whether it has really any relevance at all, or whether it's just the simple act of sending the message and intentionally sending a message regardless of the intention behind the message, if it can be construed on the other side as child luring. But also, more importantly, the analysis of text message-based evidence and text-based conversation in court and determining tone from text-based conversation, where these types of disagreements happen all the time. These were two important areas that the Supreme Court of Canada could have provided guidance on that would have had ripple effects in evidentiary ways in other types of hearings where these disputes about text-based conversations are taking place. This could have important effect on cases involving uttering threats, cases involving claims about child custody. All sorts of legal issues could be guided by the Supreme Court of Canada's assessment of text-based conversation and its admission into evidence and its intention behind the words. And unfortunately, the Supreme Court of Canada missed the opportunity to deal with an important legal issue in this case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.